I'm telling you, we've heard from so many of you on our Royal Banks of Missouri text line just about how much you are enjoying this music and how much you enjoy the song of the day. Well, a lot of artists are fed up. From Nicki Minaj to Billie Eilish, more than 200 artists from every genre have signed an open letter to AI developers and tech companies. And Tennessee became the first state that came up with laws protecting musicians from AI, artificial intelligence. John Rizvi is a good friend of the show, the patent professor and the author of 2 books on patents. Professor Rizvi, thank you for joining us.
Yeah, always a pleasure. Thank you.
Okay, so what are the legal and ethical issues around AI? We know the SAG-AFTRA union members, the actors, went on strike over AI because they were worried about their likeness being used after they would have one scene without paying them. How does this work with musicians?
So, I mean, the concern, of course, is these deep fakes and computer-generated renditions of songs and actually the likeness of artists without their consent, without their approval. And it's huge. I mean, there's been so many instances where the artists have had to come forward and deny that something was even theirs, and that's finally it's resulted in this letter, and it's worked. And in essence, they're basically asking tech companies to take some responsibility for this. But when I say it's worked, I mean there's a California Democratic Representative Adam Schiff actually proposed a bill that's targeting AI companies and asking them to reveal where they're getting their sources from, because that's what the artist's claim is based on, is that the AI is being trained using their copyrighted music and images.
What can you tell us about Amazon Maestro?
I've never heard of that.
Yeah, so I have not heard of that either. I don't know.
It sounds like it almost sounds like it's AI generated. In other words, they can take a song and recreate it, which is pretty much what we're talking about, right?
Yeah. So so I haven't heard of Amazon's launch of that, but there's certainly. They're not the first and only ones to offer that. In fact, there are a number of apps that allow not just music, but that would allow celebrity voices and images to say whatever you would want them to say. I can't remember some of the names of the online apps, but you could have, for example, Donald Trump wish you a happy birthday, and it's in his voice, it's in his likeness, it looks like a spitting image of him, and it could pass as a video. So this is bringing up some real concerns, whether it's Amazon or these other companies. At least with Amazon, there's perhaps an ability for some legal recourse. But when it's these thousands and thousands of separate apps, part of the problem becomes enforcement. Is how do you, even if you stop one or more, it's just so widespread, you never can keep those items offline. And that's where that old expression that once something's put on the internet, it's there forever. And that's part of the concerns that these artists have, is that even when these deep fakes are removed from larger supposed infringers, it's never going to be off the internet, because so many people, individual users, have downloaded it, and then they continuously, it never gets taken off. They're uploaded over time.
Professor Rizvi, a lot of these AI companies have defended their practice, and they call it fair use. But then the creatives take the position that this is a form of copyright infringement. What is fair use?
So there's several factors that courts take into account when determining whether something is fair use. But one of the most important is whether is the purpose behind the usage of certain materials. So if the purpose is educational, if it's in a school environment, it's for learning, that factors in. In the case of these AI data sets and AI companies, the tech companies, clearly the perfect purpose is a profit purpose, and that's what's behind it. So fair use is rarely applied when something is used not for its newsworthiness or for education, but for a profit purpose. Fair use is not there. The other factor is how much of the actual original work is used. So if it's just a short line or something, then you can make an argument for fair use. If someone's taking the entire song or even an entire verse, that argument goes lower. The problem with the AI data sets and the tech companies is they're not revealing where they're getting their source material from. So if the AI program has been trained using the entire music catalog of an artist, for example, the artist doesn't have the evidence to try to prove that. And that's what this bill by Rep. Adam Schiff is trying to address. He's trying to force tech companies that are using AI databases to reveal and file a disclosure with the Copyright Office explaining how their AI software has been trained. So that will provide potential plaintiffs that believe their work has been ripped off or used by the tech software the evidence to show that their original work was used.
Patent Professor John Rizvi is our guest. The Royal Banks of Missouri text line is 84126. If you have a question, the Maestro, John, is Amazon Music. They're saying it's an AI playlist generator, as you said, allowing U.S. customers on both iOS and Android to create playlists using spoken or written prompts, which can even contain emojis. So a question that I have for you that I've always wondered about, what is the difference between this kind of thing and then those compilations of, it used to be on CDs where the popular artist of the day, all of the hits would be they'd be compiled on one disc. You could get, 30 maybe songs, and they were not performed by the original artist, but they were compiled. What is the difference between this and that? And I know you've talked about the proliferation of so many apps, but did they ever fight back on those compilation discs, the artist?
Yeah, so I think the biggest difference is in enforcement, because in those cases it's really easy to identify. It's a finite number of defendants, and you actually can bring suit against them. In the case of online infringement, the problem really becomes one of an economic problem of how do you bring forth 2 million cases of copyright infringement against individual users that are doing the same thing, and that really becomes the issue. In the case of Amazon, I don't think Amazon's going to be is certainly at risk of a lawsuit because they're identifiable. But even if you remove and prevent Amazon from doing it, if this is something millions of internet users can use online and do anyway, how do you enforce that?
And Professor Rizvi,
sorry, go ahead.
Yeah. Well, I was just going to say, this is different than sampling, right? We've heard about lawsuits between one artist and another because one musician will say, may I have permission to sample this line? And the other artist will say no, and they'll go ahead and do it anyway, and then there'll be a lawsuit. They stole my music without my permission. But this is different, right?
It's different, and part of a big difference is that they are not, if they're not revealing the source, and whether it's from public domain sources or if it's copyrighted work, then one of the things that the artist has to prove is copying. And the databases, for the most part, the tech companies have been keeping confidential and protecting as trade secret information. And this bill, if it passes, it's going to put an end to that, because now they're going to have to file a disclosure with the U.S. Copyright Office revealing exactly where their programs are getting their data from.
It sounds much more insidious. I'm not diminishing anything that SAG-AFTRA, which is our union, that they were fighting for. But this does seem, as you said, John, just even worse, doesn't it?
It does because of I think mostly because of the incredible scale of infringement that's possible. And in addition to issues of copyright infringement, you do have concerns even with the right of publicity. So celebrities they make a lot of money from licensing their look and their image and their voice. And although that might not be infringing an intellectual property in terms of their patents or trademarks or copyrights, but when you have diminished the value of, say, an endorsement from a celebrity, because now instead of paying the celebrity for the endorsement, you can go to an online app, and I can't remember the name right now, but it's the one I saw was a free app. You don't even pay anything, and you can and they let you choose from a list of celebrities and have them say, you basically type in whatever you want said, and then and with their image, it's that celebrity, whether it's Obama, Trump,
Wow.
Nicki Minaj, whoever. You can have them say whatever they want, and you haven't paid a cent for that, and the artist has not benefited at all, as opposed to prior to this technology, there was an incredible industry for artists.
Called Cameo,
licensing.
right?
Yeah, yep, exactly. The artist licensing the use of their endorsement. And here, it's also an issue of even, fraud, because the endorsements may end up being like not an endorsement at all. The celebrity may not even want any association with a product or service, and now there's going to be stuff floating out on the internet of them endorsing something that they don't endorse and are not even aware of.
Professor Rizvi, to your knowledge, when a musician writes a song, do they get, is it copyrighted? Is that their intellectual property? Do they go to court and do whatever it is? I don't know if that's a patent or just copyright.
It is a copyright. There's a common law copyright the moment it's written, so they don't have to file anything. So immediately it's copyrighted. But the recommended approach is to file a formal copyright application, and then when that gets issued as a granted copyright, it's registered, and that provides greater enforcement benefits. It allows for statutory damages, for example, and then you're allowed to bring suit. So there's always the advantage of having it registered, but it would be a copyright. It's not a patent or trademark, and that's something that artists typically would do.
Are you hearing about anything in the pipeline? Because obviously we're spending a lot of time, and the artists are spending a lot of time fighting this particular advancement, but that there are things in the pipeline that we're going to be hearing about in a couple of months that are probably just as frightening, if you will.
And that's the problem, is that the law has never had to change as quickly as it's having to change now because of technology. So it's a race between technology and legal doctrine meant to keep the technology in check. It's really tough. It's no different than sometimes when you as a parent will try to control our children's use of going online and what they get to watch on TV. But it's a constant battle, because as soon as you figure out some way to stop them from going where they're not supposed to go, the kids find a way around that parental control. And that's exactly what's happening here, is the laws are not able to change fast enough to keep pace with the technology.
It is fascinating. Professor John Rizvi, the patent professor, thank you so much for joining us on the Jennifer and Wendy Show here in St. Louis.
Thank you.
Thank you. Always a pleasure.